Good evening, friends. It gives us quite an immense pleasure that on the virtual book launch and discussion on the electronic evidence in the courtroom, written by Mr. Yuvraj Narvankar, who has already taken few sessions on the channel of Beyond Law CLC, that we have become the knowledge partners. And today, there's another collaboration that is of the Advocates Association of Western India, AAWI, for the virtual book launch. And the book is being launched by the chief guest, that is Justice A.S. Oak, the Judge, Supreme Court of India. And he needs no introduction as such. His judgments, his knowledge is well received, and he's considered to be an epitome of knowledge as such. Without taking much time, since the entire session will be moderated by Rashmi Sanjinkar, I will ask her to take things forward. Before that, I will also, we are enamored by the fact that today we are also joined by Mr. Rafiq Dada, and if Mr. Rafiq Dada will remember that during these lockdowns time, we had requested in our team number of times that kindly do their knowledge sharing on the platform of Beyond Law CLC. Over to you, Rashmi, and thank you to all those participants. We are live on the YouTube and Facebook. We are also thankful to the participants who are watching us live. Over to you.
Thank you, Mr. Vikas. It's absolutely a great pleasure to welcome you all, those who are watching this program through Zoom, Facebook, and also those who are watching this live on YouTube. With the grace of God and willpower of all, we are coming out of some very difficult times. Fortunately, though the restrictions are eased as an abundant precaution, we decided to hold this program virtually. In fact, during this lockdown, we all realized that though the online event cannot match the grandeur and splendor of a physical book launch ceremony, the reach of virtual launch is much, much more than the physical one. In fact, one of the lectures delivered by the author on this very platform is heard by more than 16,000 viewers just in a span of 5 months. And that is what we think is the power of the virtual. I would request Team Beyond Law to project the screen for an introductory session. With pride, we would like to tell you that this is the first of its kind commentary exclusively on the electronic evidence with ultra practical insights, which would come handy to the civil and criminal practitioners. In fact, the publisher of this book, LexisNexis, which is one of the most leading international legal publication houses, strategically wanted this book to be available across the bookstores at the time of its launch, and therefore it is today available across all the stores and online. It gives me immense pleasure to announce at the outset that within 2 weeks of its introduction in the stores, this book has been one of the best sellers in the country. We believe that this is unprecedented considering an extremely short span of time. We are informed that there are reorders from across the country, and at some places it is in shortage. The book is soon going for its first reprint. We wholeheartedly thank all our readers and the fellow lawyers for the immense patronage and support. As our tradition goes, let's start this auspicious occasion with virtual lighting of lamp. It's my great honor to introduce the panel of guests today. I would like to extend a warm welcome to an extremely revered chief guest of today's function, the Honorable Sri Justice Abhay Srinivas, Honorable Judge of the Supreme Court of India. Candidly and frankly, there is absolutely no need of an introduction of today's chief guest, but as we all know, the formality has its own place, so let me introduce today's chief guest. Born on May 25th, 1960, Lordship Justice O did his Bachelor in Science, completed his LLM from Mumbai University, and enrolled as an advocate on June 28, 1983, and started practicing in Thane District Court in the chambers of his father, Sri Srinivas Oak. In 1985-86, he joined the chamber of V.P. Tipnis, a former judge of the Bombay High Court and former Lokayukta. Over the years, Lordship has appeared in several important matters and in public interest litigations during his time as an advocate before being elevated as the Honorable Judge of the Bombay High Court on 29th August 2003. Lordship was appointed as a permanent judge on November 12, 2005. His tenure at the Bombay High Court is the one that the Bombay Bar would never ever forget. His courtroom number 13, was the source of inspiration for many, both at the bar and the bench. Lordship passed several landmark judgments, including the bans on noise pollution, illegal constructions, and potholes on roads. During his tenure at the Bombay High Court, his grasp over each and every branch of law, the meticulous preparation of even the last brief on his cause list, and near perfection judicious gestures on the bench simply mesmerized everyone, and in fact was a source of curiosity for many. Lordship was elevated as the Honorable Chief Justice of Karnataka High Court on 10th May 2019 and occupied this esteemed position till 30th August 2021. The way in which Lordship conducted the functioning of the judiciary in the trying times of COVID-19 was witnessed by the entire country. His gestures during these times not only fortified the people's faith in judiciary, but in the humanity, reminding all of us what is written below the statue of Justice M.C. Chagla in the Bombay High Court. A great judge, a great citizen, and above all, a great human being. Lordship was elevated as a judge of the Honorable Supreme Court of India 31st August 2021, and in a short period, as we all know, Lordship has passed several landmark judgments. We are extremely proud and happy to have Lordship as a chief guest for this program and would remain forever grateful to him for being here. May I now introduce the guest of honor of today's program, Mr. Rafiq Dada, Senior Counsel and former Additional Solicitor General of India. One of the most leading counsels in India, Mr. Rafiq Dada actually needs no introduction. For decades, we know him as one of the most senior and erudite counsel of the original and the appellate side of the Bombay High Court and Supreme Court of India. Mr. Dada began practicing law on the original side of the Bombay High Court in 1964 and was designated as senior advocate in September 1987. He was the first Additional Solicitor General of India of the Western region. In the capacity of law officer, he appeared in extremely wide variety of matters ranging from constitutional law to IPR and securities law. His reported judgments runs into several thousand pages. Mr. Dada was Vice President of the Bombay Bar Association consecutively for 2 terms and led the delegation to the Bar Council of England and Wales. In 2008, Mr. Dada was honored by the then Prime Minister of India and Chief Justice of India on National Law Day for his immense and gigantic contribution to the field of law. Mr. Dada has been awarded several awards and accolades by the leading institutions and bar associations. It gives us enormous pleasure to have Mr. Rafiq Dada as our guest of honor today. Let me now introduce AAWI, Advocate Association of Western India, is the Association of the Eminent Lawyers, who have been at the forefront of several movements and has produced some excellent legal minds of India for over decades. We today are very happy to have an association with this body of the lawyers that has always kept the flag of professional excellence and integrity flying high. We have amongst us today Advocate Sri Sanjeev Kadam. Mr. Kadam is practicing lawyer in Mumbai for over 32 years in civil and criminal law. He has also been a government leader. He has been at the helm of many philanthropic associations and trusts. Presently, he is Vice President of Advocates Association of Western India, an association established in 1864. We welcome him on behalf of LexisNexis and Beyond Law. Now coming to today's platform, Beyond Law CLC. I don't think anyone here would be unaware of Beyond Law CLC, the platform for today's book launch. It is this platform that has kept the mental agility and intellectual faculties of the lawyers extremely agile during the trying times of lockdown. Every lecture on this platform has received a tremendous response from all over India. In a very short span, the subscriber base of this channel has crossed huge number of 27,000 and still growing fast. The choice of subject, choice of speaker, and an extremely hands-down practical approach have always been the distinguishing point of this platform. I thank Mr. Vikash Chatrat, a leading counsel with 27 years of experience of practicing in Punjab and Haryana High Court and former additional standing counsel for Chandigarh Union Territory for effectively coordinating and managing this platform. We welcome all the dignitaries with folded hands and grateful minds. I call upon all the dignitaries to kindly join us for launching of the book Electronic Evidence in the Courtroom. I request Mr. Vikas to highlight videos of all the dignitaries and request the dignitaries to kindly hold the book in their hands so as to mark its official launch.
Thank you. Thank you, sir.
I declare that the book is officially launched at the auspicious hands of the dignitaries. I request Advocate Yuvraj Prabhakar Narvankar, the author of this book, to say a few words. A short introduction to him. He is a gold medalist in law from INS Law College, Pune, and merit holder in LLM from Mumbai University. He is admitted as a fellow of prestigious Chartered Institute of Arbitrators at London. He is one of the youngest panel arbitrator at Singapore International Arbitration Center, also known as SIAC. He practices in Bombay High Court. He is an avid speaker and writer. Over to Mr. Narvankar.
Thank you so much, Rashmi and LexisNexis, for the wonderful introduction. Obviously, Rashmi has introduced all the guests very ably. I really don't think there is anything I can add. But out of 5 minutes that I'll have 1 minute about the personalities that I am fortunate to have as the dignitaries. And a confession I have to make at the outset. Ecstasy and joy that I feel today because of the presence of Lordship Justice Oak and Mr. Dada is way more than the joy that I felt after writing and publishing this book. There are certain personalities who, unknown to you, leave a very deep impact, at the same time very subtle impact on your mental faculties. And believe you me, it's very difficult to express in what way and what manner they shape you. And I must confess that these are the two personalities that have shaped not only me, but the future of several lawyers and a generation of lawyers. The members of Bombay Bar would concede and would agree with me that the courtroom number 13, as Rashmi rightly said, was not a courtroom, but it was actually a university where we saw the law in all its glory. Lordship's every gesture on the bench taught us something. made with the integrity, extreme perfection, unfailing sincerity, and most importantly, what we saw was an extreme hard work without even a tinge of irritation that generally comes along with it. And therefore, the only thing that I will say is that, Lordship, you mean a lot to this bar, way more than you think. I'm extremely thankful to Mr. Dada, my senior, for being here. Whatever good things have happened in my life, I owe it all to Mr. Dada. And the words would really not do justice to the man of his stature. So I wouldn't venture into that at all. I wouldn't say much, because these two dignitaries that we have, the fortune that we have of having them today, somewhere inside I feel very bad that I realize that the words are not expressing how intensely I feel. So better I will not try to articulate it. The only feeling that goes little closer to what I feel is gratitude. Coming to my book, Rashmi and all the audience, it was a dream. Every lecture that I gave on electronic evidence, till date, I had a fortune of delivering around 270 lectures on Evidence Act, cyber law, electronic evidence. Each of these lecture was followed by question and answer session, as we all know. Unfortunately, the organizers of these lectures do not allow the lawyers to ask specific personal questions. They say that you do not ask your own questions that you face in the course of your trial. But I was finding a specific trend of those questions. There was a specific pattern in the questions which were being asked to me. But unfortunately, as I told you, the organizers were not allowing the personal questions of the lawyers at the end of my lecture. And therefore, I started feeling that I am not doing justice to the audience. Even if one query remains unaddressed, it's not done. Because ultimately, we must understand that it is not a personal query of a lawyer, so to say. It is something that pertains to his client, who is helpless and is expecting some justice. The lawyer is just the face of a client. And the person who is standing behind the lawyer is much, much more important than the lawyer himself and the system, because the litigant is the edifice of this whole system. It is with this genuine intent of addressing each and every question that a civil or criminal lawyer will face that I thought of writing the book. The process went on for 3.5 years. I traveled a lot because, as we all know, the UK and US have become very sophisticated when it comes to acquisition of electronic evidences. So I really was in search of the best practices. I wanted to Indianize them. I wanted to make them simple. And I was so eager to put it on paper that after completion of my manuscript, to my horror, I realized that I had never thought of a publisher, the book proposal, and all those things. Fortunately, the things fell in place very beautifully and very quickly. Coming to the contents of the book, this is not really a book. This is more of a do-it-yourself toolkit or a manual, as we may like to call it. As I see the book, it's 20% theory and 80% of a practical application. I have tried to explain and demonstrate how you use a hash value, how to create a forensic image of a hard drive, how to use the hash value to authenticate an electronic evidence, how to create forensic image of a hard drive, how to recover the deleted data, how to prove and disprove all kinds of electronic evidences. I have tried to give some free tools and links to the lawyers. So you need not rush to cyber expert for every small thing. We can do some things ourselves at our office. And I have tried to make it as friendly as possible in as simple language as possible. The last chapter is about the cross-examination in my book, where I have discussed how can we conduct the cross-examination of the proponent of various types of electronic records. So this book basically tries to cover the entire life cycle of an electronic evidence, from its acquisition, forensic analysis, to its production and cross-examination. I have personally used extensively the figures, pictures, diagrams, and snapshots, because the science is today telling us that the lawyer's right brain is very active, and the right brain is fond of images and pictures, and left brain is fond of arithmetics. So I have tried to put in as many images as possible in the book to make it as simple as possible. I hope you would like it. I'm extremely overwhelmed with the feedbacks, responses, and the love that the book has received from all over India. I am told by LexisNexis it's going for a reprint in a span of 2 months, and it's an extremely overwhelming gesture. I thank LexisNexis, who shown such an interest in my manuscript, made me write even the last few chapters, which were not earlier part of it. I thank my parents. It's my family. It's for all their support. Couldn't have been possible without them. And if there is anything that you feel the book lacks or does not address, please let me know. I'll try to incorporate that in the reprint. Ultimate beneficiary of this must be the litigant. That's the genuine intent of mine. Thank you so much, Rashmi. Thank you so much, all the guests, for being here. Thank you. Over to you, Rashmi.
Thank you, sir, for that heartfelt note and sharing with us all the thoughts that have gone into making this book. I would I would now like to call upon Mr. Sanju Kadam, President of Advocate Association of Western India, to say a few words. Mr. Sanju Kadam.
Join.
Might be some connectivity issue at his end. I think I'll ask Vikas ji to just get in touch with him. I think we can ask Sir Rafiq Dada sir.
Okay. I would now like to call upon the guest of honor today, Mr. Rafiq Dada, Senior Counsel and former ASG, to address the viewers.
I hope there is no issue of connectivity in my case.
No.
No. So, His Lordship, Mr. Justice Oak, Honorable Judge of the Supreme Court of India, my esteemed colleague, Mr. Sanjeev Kadam, who will join us, Mr. Vikas Chakrat, Ms. Rashmi Shajanikar, and of course, the author of the book, Yuvraj Narvankar, ladies and gentlemen. My Lord, Mr. Justice Oak, who's with us this evening, and all the esteemed speakers who precede me will have probably considered the worth of Mr. Yuraj Nirankar. But let me tell you something. I deem it a great privilege to be associated with this function, which is to release this book, which, as you know, has already become a bestseller. It gives me great pleasure to record that the author is Mr. Yuraj Nirankar. Yuraj started his career at the bar in my chambers. From the first day, he brought a certain dedication and a culture of hard work. He studied every brief and looked up every facet of the legal issues involved. Being a gold medalist and an outstanding student, he brought to bear on every matter his touch of class. All of us working in the chambers saw that spark on him, and especially the felicity and ease with which he handled computers. Yuvraj Nirankar has since then grown from strength to strength. Today, he has his own independent chambers, as you have seen on the video. He has his own bunch of juniors and interns surrounding him. Humble as he has involved me at all stages of the milestones of his life. The opening of his new office, his early briefs, his idea of working on a book, his visit abroad, and now this release of the book by the Honorable Mr. Justice Oak. As Mrs. Rashmi mentioned, Mr. Oak was a distinguished judge of the Bombay High Court, Chief Justice of Karnataka, and now a distinguished judge of the Supreme Court, has a special place in the hearts of many members practicing in Mumbai. So it is a great honor to have him in today's function. It is a trite matter to say that law is a vast ocean. It has great dimensions, and many great jurists have carried it to high levels. The 21st century has seen many great laws and many great problems facing society. The new jurisprudence includes laws on environment, laws on securities, and many new categories of criminal law. But the new frontier is the law relating to electronics, which is really part of the digital age. This book, Electronic Evidence in the Courtroom, a Lawyer's Manual, which is being released today, is going to be one of the important elements, an important piece of study in the part of the evolution of this system of jurisprudence. It is perhaps the first important book of its kind in India, which, as you know, as a country, we are at the forefront of the IT movement, and it is but fitting that this book should be written in the Indian firmament. In this electronic age, the courts have fought against the perils of physical hearing in the pandemic. Virtual hearings have made access to justice easy. Every lawyer today must familiarize himself with electronics and the study of electronic evidence in the court. This book, therefore, in my respectful submission, is really a part of the felt necessity of the present times. I have skimmed through this book when Mr. Yuvraj came to my chambers and showed me some transcripts of it. Every chapter in the book brings out some important facets of electronic evidence. The book analyzes electronic versus documentary evidence. Every nuance is considered with case law. The book deals with important aspects of a certificate under Section 65B of the Evidence Act. Various issues like CCTV in evidence is dealt with. Important issues like reliance on CD or DVD is dealt with. The author has analyzed important provisions of the IT Act 2000 and the IT Certifying Authorities Rules 2000. The method of dealing with digital signatures is considered, and reference is made to the changes in the IPC and also the provisions of the Indian Evidence Act. Issues of proof of digital signature, Section 47A, issues of presumption in the Evidence Act, and especially the changes made in the 21st century law in India, taking into account the electronic evidence, has been brought out very clearly by the author. The author has dealt with every aspect. He has said how a matter has to be proved, and he has also said how the opponent has to meet what is sought to be proved against him. So he has taken a totally even stand, both against the proponent of the evidence and the opponent of the evidence. He has dealt with illegally obtained electronic evidence and the topic of forensic investigation. In my humble view, the book in its own way is a masterpiece and is indispensable for any lawyer in this digital age. I could say more, but I want to resist the temptation of doing it because I want people to read the book and savor its contents and enjoy every bit of it. Also use it as a part of the practice, which many of my colleagues will certainly do. On this occasion, I congratulate Mr. Yuraj Nirankar. It's a proud moment for his advocate father, Prabhakar Nirankar Sahib, and his mother also. It is also a proud moment for the other advocates in the family, the three sisters, Rashmi, Shilpa, and Neha. I wish Mr. Yuraj all the very best. He is at the threshold of his career. He has lots to do in future. He has to convince hundreds of judges of the cases which he is arguing in court. He has to argue hundreds of matters. He has to help in the delivery of justice. He has now approached a new frontier in law. And to my mind, he has made an indelible contribution to the study of law.
I've been just apprised that Mr. Sanju Kadam had a difficulty with the connectivity issue and rightly said, Mr. Rafiq Dada, I'm just reminded of two words of Mr. Yuvraj. Ye to aghaaz hai, anjam to khuda jaane aur acha hi hoga. And they say that the well begun is half done. So Yuvraj's book doing well is a testimony of that said fact.
Thank you so much, sir. Thank you so much.
And the fact that I'm just seeing live since I'm a moderator at that way. On the YouTube, it's doing well. People are receiving this book launch very well on the YouTube. That gives a very sign that people are actually well receptive as and when Yuvraj comes on the Beyond Law CLC as well as on the Law LexisNexis. Over to you, Rashmi. You can unmute yourself.
Sir, we are extremely thankful for your brilliant insights. We are deeply grateful for all your kind words and pat of appreciation. As we all know, Advocate Sanju Kadam has some connectivity issues, so we will move forward. I would now like to call upon the chief guest of today's program, Honorable Sri Justice Abhay, the Honorable Judge of the Supreme Court of India, to deliver his inaugural address.
Good evening, Mr. Rafiq Dada, Senior Advocate, Mr. Yuraj Narvankar, the author of the book, the representatives of publishers, the representatives of Beyond Law PLC 1, members of the bar, and ladies and gentlemen. It is indeed a privilege for me to be part of this function, especially when Mr. Rafiq Dada, Senior Advocate, is part of this function. I have been extremely benefited from whatever I learned from Mr. Rafiq Dada. I had privilege of appearing against him in many matters. In one or two matters, I appeared with him. And of course, greater privilege was when he appeared before me as a counsel. I must compliment Mr. Narvankar for writing this book titled Electronic Evidence in the Courtroom, a Lawyer's Manual. This is completely a new subject, and I find that such a book was needed because, according to my limited knowledge, there is not a single book available on the subject. I have meticulously gone through the book. It is divided into 9 chapters. In the first chapter, Mr. Narvankar has covered a very important topic that normally does not find place in any of the books on the subject. He has incorporated basic information about computer hardware, metadata, cluster, the procedure for recovering deleted data, the concept of memory, hard drive, storage devices, optical media, and cloud storage. Very importantly, he proceeds to describe the distinction between volatile memories and non-volatile memories. He has discussed in detail the concept of software as well as various kinds of networks. He has rightly stated that electronic evidence is the most difficult to deal with on account of its high volatile nature, unlike paper documents. He is at pains to explain that without basic technical knowledge, lawyers will find it difficult to deal with electronic evidence. I must share my own experience with all of you. In 2013, as a guardian judge of the course of Metropolitan Magistrates in the city of Mumbai, I had arranged a seminar on information technology law and cyber laws in room number 46 of the Bombay High Court. The workshop was for judges of the City Civil Court and the Metropolitan Magistrates in the city. Incidentally, many of the sitting judges of the Bombay High Court attended the seminar. A sub-inspector of police attached to cyber cell of police at Bombay addressed us. After hearing his address, all of us realized that we hardly know anything about the technology, we hardly know anything about cyber laws. Many things which are not known to us were told to us by that sub-inspector. And from that date, I realized that electronic evidence is most challenging subject. As the Chief Justice of Karnataka High Court, I had requested our Judicial Academy to hold workshops on cyber law and information technology law in all districts. We began at the end of 2019. We used to arrange workshops which were attended by not only the judicial officers, but the members of the bar, the prosecutors, the police officers, and even some of the government officers. That experiment proved to be very successful. We used to arrange day-long workshops. Unfortunately, we could not complete the target of having such workshops in each district due to pandemic. However, whenever I attended these workshops, I used to realize that we need systematic training on this subject. Coming back to the book of Yuraj, he has dealt in detail with leading decisions of the Supreme Court, including Anwar, Sonu, Arjun Pandit Rao, and various other decisions. He is bold enough to discuss the difficulties created by some of the earlier decisions of the Supreme Court and the impact of those decisions on litigation. I found chapter 4 of his book to be very interesting. He has dealt with exhaustively with the issue of proving various kinds of electronic records such as CCTV footage, emails, CDR, audio visual click, snapshots, etc. By incorporating charts in the said chapter, he has simplified the issue, which is otherwise very complicated. He has also dealt with the important issue of integrity and authentication of electronic evidence. Now we are facing one more intricate issue when it comes to electronic evidence. It is regarding illegally obtained electronic evidence. There are serious issues concerning illegally obtained electronic evidence. The issues related to privacy breaches in the context of Article 21 of the Constitution of India. I am glad that even this aspect is dealt with in the book. Any book on this subject would not have been complete without discussing Section 65B of the Indian Evidence Act and everlasting controversy associated with it. That part of the book which deals with Section 65B is very interesting, and I'll commend the lawyers to read it very carefully. The members of the bar who are practicing on criminal side must study chapter 7 very carefully. It is on forensic investigation. In fact, issue of forensic investigation nowadays arises not only in criminal matters, but also in all categories of matters. When I read the book, I realized that there is one more important aspect which may not directly concern with the electronic evidence, but it has some nexus with the electronic evidence. As all of us know, in the last week of March 2020, all the courts, and especially High Courts and Supreme Court, shifted to video conference mode. In those days, we encountered a situation where some of the lawyers used to write to us and tell us that there is no basis for conducting video conference hearing. It is completely illegal. Fortunately, E-Committee headed by Justice Chandrachud worked overtime, and Supreme Court E-Committee came out with model video conference rules for the court. And many high courts immediately adopted the rules by making necessary modifications. The most delicate part of the said rules is recording evidence through video conference. The rules deal with a situation where witness will be at remote place, the judge will be sitting in the court, the lawyers will be at different remote places. The issue of showing documents and articles to the witness who is in a remote place is very intricate. The same is the issue with confronting a witness with a document in his cross-examination. Another issue is going to be about proof of electronic evidence when evidence of a witness is being recorded through VC. I hope that in the next version of this book, Mr. Narvankar deals with this aspect as well. Effective implementation of the rules regarding video conference hearing is the need of the hour. So far, we have seen 3 waves of pandemic of COVID. All of us are hopeful that we won't be able to face the 4th wave. But we have to remember one thing, that whatever limited functioning of the court could take place, that was only through the technology of video conference. And as Mr. Rafiq Dada has rightly put it, video conference hearing has its own advantages. Of course, today is not the day to discuss that. But this aspect also needs to be considered in the next version of this book. There is one more suggestion I have to make to Mr. Narvankar. Look into the nature of the subject, this book will require frequent updating. He himself has referred to various decisions of the Supreme Court, especially on 65B, and the changes which occurred with the passage of time. Apart from regularly updating the case law, even the information regarding technology contained in Chapter 1 requires frequent updation. Where we began about 20 years back in our offices using the computers, we used to use floppies. At that time, we never imagined that after a few days, few years, we'll be using pen drives. So technology keeps on changing, and therefore updation of his book on technology is also very much needed. There are many young members of the bar who have joined today's function. I want to tell them with some kind of emphasis. In the years to come, the major part of evidence in our courts will be electronic evidence or documents in soft form. In what form those documents will be produced, I cannot predict because technology is improving every day. The floppies and CDs have become obsolete within span of 10 to 15 years. Therefore, it is all the more important for the young members of the bar to remain acquainted with this law, the law regarding proof of electronic evidence. Today, we are dealing with only few forms of electronic evidence. But as the technology and science advances, we don't know what kind of electronic evidence we'll be dealing with after 10 years or 15 years. Therefore, the members of the legal fraternity and especially younger members of the bar should be very well equipped to deal with electronic evidence. As a member of the legal fraternity, I must acknowledge the contribution made by Mr. Narvankar. I must also thank the publishers for making available this manual, which will be immensely useful not only to the judges and members of the bar, but also to the police and other stakeholders in the institution of judiciary. I wish a great success to Mr. Narvankar in his future endeavors. As the earlier speaker said, the book is already a success. Maybe this may be just a beginning of success story for Mr. Narvankar as author on legal subjects. I thank the organizers for giving me this opportunity to participate in this function and to interact with the members of the bar and especially younger members of the bar. Thank you very much.
Thank you so much, sir. Thank you so much.
Sir, we cannot thank you enough for your most meticulous exposition and your absolutely genuine remarks. Sir, every word.
Rashmi, and only one addition. What Lordship expressed, the need of constant revision is something that is so pertinent because I can see those problems arising even right now because what is written 6 months back is now about to become outdated in a span of 2 months, as Lordship pertinently pointed out, and this is the problem that the publishers and we are facing alike. So that just in fact, and I'm so thankful to him for giving these inputs because each of it is an absolutely to the point and pertinent matters. I'll take each of them. I and publisher will take that into account and will ensure that whenever the book comes out, it will be always updated, may it be the judgment or may it be the software aspect of it. That thing we will ensure. I'm so much obliged to him. Over to you, Rashmi. Thank you so much, sir.
Thank you, Yuraj. Sir, every word that you have said is something that all of us would cherish in the times to come. Thank you so much once again. We are extremely grateful to the honorable dignitaries for joining us for this book launch today. We are overwhelmed with the response of the audience, subscribers, and the viewers, and we are equally grateful to them. We thank the team LexisNexis, team Beyond Law CLC, and Advocate Association of Western India for their patronage. Over to Advocate Vikas.
Thank you. And what Justice A.S. Oak said I'm also reminded of the words, they say that old order changeth, yielding place to new. So same is what the law evolves. And when Justice Oak was taking us hurriedly through all those chapters, I was feeling that as a young lawyer, when we joined the profession, it said that the difference between an ordinary lawyer and that extraordinary lawyer is that extra effort. So when I said that everybody, those who were there, got the book to read, everybody read it, but that extra effort of Justice Oak to go through that book shows what is the difference. And I'm again reminded of one of the dialogues in the movie, wherein it was said, what is the difference between Shahenshah and Basha? He says that there's a long journey. So that's the difference between the bird eye view and the hawk eye view, where one can catch the easy things easily. So thank you all the participants. We are enamored by the fact the way the book has been launched, the book has been received, and it will continue to receive. And as I can again say that Yuvraj Narvankar's 2 sessions on electronic evidence are already available on the Beyond Law CLC channel. I would ask Yuvraj to tell the date, because I'm seeing on the YouTube also where they want that the next session can be taken on this thing. Over to you, Yuvraj.
Oh, thank you so much. Certainly, Vikashji, we will have one more session on this, and I'll inform the date very soon. I again thanks from the bottom of my heart to the dignitaries for taking the time out from them extremely busy schedule. Thank you so much. It's just a blessing. Thank you.
Thank you. Everyone stay safe, stay blessed. Namaskar. Jai Hind.